Right, everyone. So it's great to see you all. My name is Jason Grillo with the Oscar team. It's my pleasure to welcome you to our event today talking about the open standard carbon removal offtake agreement that is Oscar. We launched this, for some context, we launched this effort at a CDR 30 event, virtual event, as part of COP 30 a few weeks ago, with the intent of putting a new kind of standard open carbon removal agreement out into the world. What we're going to do today is have Simon Puleston Jones interview one of our Oscar team, Peter Mayer, about why we're doing this, why Oscar exists, what it means for people transacting in the space, and how it can be best used for contracting for durable carbon removal. To let you all know, this event is being recorded, and we will have about 45 minutes of discussion between Simon and Peter, Simon interviewing Peter, and then we'll go to Q&A. So as questions arise, please put them in the chat so that our Oscar team can evaluate and then pass along to Simon and Peter to answer. So with that in mind, we're going to get started. Once again, welcome. And Simon, please take it away from here.
Thank you very much, Jason, and thanks to the Oscar team for the opportunity. Good morning, good afternoon, or good evening, depending on where you are located. As Jason said, over the next 40 minutes or so, I'm going to be putting the questions to Peter Mayer, who is a partner at Stairs, Dillenbeck, Finlay and Mayer, and also one of the co-founders of Oscar. Through the next 40 minutes or so, we're going to start with why Oscar? Why do we need a new template at all? Then what does it do? How does it function? And where do we go from here? Jason is going to invite you to ask questions as we go along. Rather than interjecting, we're going to leave 15 minutes at the end for Q&A. So if you put your comments in the chat, then Jason will filter those and he will do the moderation of the Q&A at about quarter to the hour. And just a bit of scene setting before we get started. As you'll be familiar, this is not the first template that we have in project-based carbon markets. We have the IETA templates, the ISDA template for secondary market transactions. Frontier have a template, Microsoft have a template, and no doubt many of you who are buyers have your own house templates, and many of you who are lawyers have your own house templates. The focus of Oscar, just to reiterate, is on durable CDR, i.e. carbon dioxide removals that have 100 years or more of storage. So not just engineered CDR. So we're talking about direct air capture and BECCS and biomass carbon removal and storage in ERW, but also concrete mineralization and other things that aren't necessarily entirely engineered. It could include biochar conceptually. Durable CDR often involves first-of-a-kind technologies, and depending on the type of durable CDR, may involve the transportation of CO2 emissions and the durable storage of those emissions. And then a final point to note before we jump into the questions is that as a new template, Oscar is a starting point for both buyers and suppliers, and not something to which you should simply add your signature. This is something that would be negotiated, and it will iterate as a template over time. And over time, Peter will talk more about the process of how changes such as new pathways or changes that are consistently made to the agreement, suggesting the template needs an update, can therefore be incorporated into future versions of this. So with that, welcome, Peter. Welcome, everyone. And Peter, perhaps you could start by answering the question, what's wrong with the existing templates? Why do we need Oscar at all?
So the idea about Oscar was born about a little over a year ago when one of our co-founders, Glenn Morley, held a closed-door buyer session, and one of the on top of the list of issues why buyers are often hesitant or reluctant to get into the CDR market is the lack of standardization of legal documentation in this context. You're right. There's the frontier contracts out there. Microsoft is widely known. IETA has published a few templates. But apparently none of them have really been able to have a breakthrough, right? Frontier and Microsoft are very much sort of centered on the particular buyer, protecting them. The AITA templates are incredibly helpful, I find, but they are a little bit outdated. They, you know, they were just published a few years ago. So Glenn, after he had this conversation, he spoke to me and said, is there something we can do about this? So we put our heads together. Glenn got Jason on board, and then sort of we started working on a template. And the way this came about is basically we didn't reinvent the wheel in the sense of we got to start from scratch. There are things out there that have been widely used, right? So we were picking things from transactions that we had seen, and also from other initiatives that are out there. For instance, the National Renewable Energy Laboratory of the Department of Energy, they're working on a similar template. Those discussions were also helpful and influenced this kind of this initiative. So what we try to do is something that works as a baseline for people to start with that have not had a huge experience or exposure to CDR. We want this market to scale. We need to get more buyers involved. There is really no market here, right? If Microsoft purchases 90% of CDR credits, that's not really a market. So it needs to be more diverse. We need to get more people involved. And this is basically a tool for them as a starting point. There is an educational element to it. Well, we also got the guidebook that one can read together with the contract that puts things into perspective, explains some of the terminology. So this is really something that can be used by anyone who says, I'm interested in CDR. Let's take a look. And I think there's a lot of educational material in there, informational material. When I got into CDR a few years ago, I wish there had been something like this. And many lawyers, there are only very few lawyers in this space that have a CDR focus, and we need to get more lawyers involved. If we want transactions to scale. So this can be a very helpful tool for any lawyer who is interested in CDR and hasn't had any exposure.
Absolutely. And you and Glenn and Elena and Jason were the initiators of this template, but you weren't creating it in a bubble. So which other stakeholders did you engage in, and how did you balance the differing and competing interests of suppliers on the one hand and buyers on the other when creating this template?
Right. So this is the template in the form it was published. Is basically an abridged version of what we had developed previously, right? So that I think one of the people we spoke to during the process said, I think you have built a Bentley here. But for someone who's just driving, for someone who just made his driver's license, a new CDR buyer, this is a bit over the top and can be too confusing. So we've sort of downsized it a little bit to make it more digestible. So we spoke to buyers, we spoke to suppliers, we spoke to intermediaries. One of the main concerns that were raised is so there are a few things that we just, didn't cover in this agreement. For instance, there is no most favored nation clause in there. There is no right of first offer or right of first refusal in there, right? There are comments in the guidebook explaining, well, maybe if you are a buyer and you would like to have these kinds of clauses in your agreement, feel free to raise them during your discussions with the supplier. This agreement for now doesn't have it. There is also when we talk about, maybe we're getting already a bit ahead of ourselves and getting too much into detail, but when we talk about most favored nation clauses or right of first refusal, they also have an impact, obviously, of bankability on this contract, right? So we also wanted to have a version that makes it possible for a supplier to go to a lender, to go to a bank and say, hey, this is the agreement that I've signed or that I'm about to sign. Is this something, you can work with? So we've also spoken to lenders. What the feedback we've got is basically that they said this is something we could work with, right? There's no bank out there who says this is a perfect agreement, right? They would have to, if you send a document, an agreement to a banker, they need to get their legal department involved. So we had to, keep this sort of on a very sort of informal level. And there's obviously no, definitive statement from any bank to this, but but the feedback we've got, it is something that they could work with, which was also important to us, right? It makes no sense to build a perfect offtake agreement from a buyer's perspective, but then it becomes a one-legged instrument because you can't use it to get a loan. Both of these things need to work together, and none of which is in a vacuum. So that's also something that we try to keep in mind and try to accommodate.
As you say, bankability will be a key part to adoption of this template over time. We've mentioned there are already other templates in the market, but what's genuinely innovative or differentiating about this template versus others that are in the market?
So I think, first of all, we have received input from numerous stakeholders, suppliers, intermediaries, buyers, financial institutions. The templates that are out there, maybe except for the IETA one, which they also have sort of a very neutral approach in putting templates out there. Everything else that out there has a perspective of the particular entity making it public, right? Frontier publishes. It's a perfectly fine agreement. It's very well drafted. There's nothing wrong with the agreement per se, but it is obviously drafted from the perspective of Frontier, right? And the people in the entities in that consortium, they're designed to protect the buyer. So we were trying to find something that is a bit more balanced. Oscar is more favorable to the buyer than to the supplier, I would say, right? But it does, and the reason is we want to get more buyers involved into this market. This eventually also helps suppliers, right? If all suppliers run after Microsoft, that's not going to be sustainable, right? We need to get more buyers involved, and that only works if we use agreements that work for buyers where they feel protected, especially when they get into a new market they're not familiar with. And at the same time, we need to keep in mind that suppliers are early startup companies. It's a nascent industry. Some of the technology may not be as developed as we wish it would be. So we need to keep these things in mind and balance them. And that's what we are. And I think in that way, in that sense, Oscar is different to other templates that are available. Frontier is also in Microsoft. They're very complex agreements, right? They're not easy to read. I mean, even for an experienced lawyer, it's not, it's complex. We try to develop something that can sort of easily be understood and can easily be read. And it's a baseline. We're not saying this is the perfect agreement and this is just you need to fill in the blanks and sign it. That's not what it is, right? But it is an easy way into understanding CDR offtake agreements.
Yeah, and as you say, having the buyer's interests appropriately protected will be important for adoption of this template, because typically it's the buyers who are dictating or at least leading on the terms in any negotiation. So we've started with the whys. We're now going to move on to the what and the how. What does it actually say? How does it work, and so on? And I can see a number of questions coming through in the chat already, and encourage those to keep on coming. And Jason will then put those questions to Peter at about 1:15. So moving on to the actual template itself, one of the critical shortcomings of the market can be around MRV. And so what does the template require around measurement and reporting and verification, audit rights, data access, and so on? And noting your comment a moment ago that this is designed to be buyer friendly, are all of those things around MRV, audit rights, and data on the projects practical for suppliers in practice?
So what we've done in terms of MRV, we've followed I think a structure that has been sort of I would say widely adopted in the industry so far, right? So there is so the onus of the MRV process is on the supplier. The buyer has sort of certain rights in terms of audits, reporting requirements, updates as to the status of the project, as to the with respect to the MRV process as well. There's a consent requirement. So if the MRV process sort of changes, if there are any amendments to the project that would require any kind of updates, it needs to be reported to the buyer, and the buyer needs to give its consent. So MRV is a critical component in CDR. We got to make sure that the credits are being issued follow the MRV process and are properly issued. And that is a key criteria for any buyer. Right? They need to be certain that they're getting what they have been promised. Credits are being issued in the future. So there is obviously a process involved from signing an agreement today, but getting a credit in 2 years. And that is, and obviously that's the supplier's responsibility to take care of that process. A buyer would say, I don't even know what you guys are doing. I just want to have my credits in 2 years. I don't want to get involved in this. I don't have the capacity. I don't have the experience. I don't, and it's not really my task. So the onus for this process needs to be on the supplier. I think that's sort of in any kind of offtake agreement. I haven't seen any other offtake agreement where it would be different. And this one follows that standard. but it is not sort of, it's not like that the buyer could request all kinds of information every month and sort of it doesn't have sort of investigative supervision rights that would interfere with the supplier's project. Right? Developing a project, issuing credits, requires a lot of time and effort, right? And we want to make sure that suppliers are able to focus on their daily business and are not being overburdened with reporting requirements to a buyer. So again, we've tried to balance this out, giving sort of buyer a sense of security, but not overburdening the supplier with complex and cumbersome reporting requirements.
Yeah. And clearly, can the document be used for both spot and forward transactions, or is it designed with one over the other? If it's
right. So,
forward, so perhaps address that one first.
Right. So this is, it's designed as an offtake agreement, as sort of the more complex agreements among them, right? There's a pre-purchase or prepayment option in the agreement. It's not, it's not drafted as a spot agreement, but it could easily be. Any experienced lawyer could easily amend this to make it a spot purchase agreement without too much effort. So that's also an element of what we had in mind when we sort of drafted it. Was like it works as a baseline, and I think with a little bit of work, it could become a pre-purchase agreement or a spot agreement, right? So it's there isn't too much. I don't think there's too much work required to go either way.
Yeah, it's easier to take out force majeure and change in law provisions than it is to put them in when they're not there already. And to that point, how does Oscar manage the delivery and performance risk? What happens if there's under delivery or delays in generating the credits or just complete non-performance?
Right. So there is, and this is something for which I would like to give credit to the process that, or the discussions that we had with the National Renewable Energy Laboratory. They came up, so that is a sort of initiative by the US Department of Energy. And one of the concepts that came up in those discussions, which we then sort of reflected in our agreement as well, was that there is a distinction between a generation shortfall and a delivery shortfall. I think most agreements just sort of have a delivery shortfall and don't really, pay attention as to why there is a shortfall. The generation shortfall aspect sort of tries to reflect circumstances that are outside the supplier's control, basically. Credits aren't being generated for no fault by the supplier, right? And so there is a distinction between the generation shortfall and the delivery shortfall with slightly different remedies. Right? In a delivery shortfall, both agreements eventually a buyer could terminate if there's if no credits are delivered. There's a termination payment requirement for the delivery shortfall, which is a bit more sort of punitive. But the general principle would be if there's a shortfall, there is sort of a catch-up period for the supplier, an additional period of X months during which they can make up the shortfall, which is, and then there may also be sort of monetary damages, sort of price adjustments, possibly if the delay is too long. When we get into these clauses, again, one needs to be a little bit cautious in terms of bankability, right? Because a lender would say catch-up clauses are great for the supplier, but how do I know when I get my loan repaid, right? So again, there needs to be a balance, but the general concept is there's a catch-up period for the supplier. They get an additional time to deliver the credits that they haven't delivered on time. And if they don't, that's being considered an event of default. And then buyer can terminate and claim potential damages. We all know that given that many of these companies are early startup companies, monetary damages may not be worth nothing at the end of the day. Um, but it's at least in the agreement.
And increasingly, the word durable is a really critical word in terms of emphasizing that it's not just about receiving delivery of the credits that you bargained for, it's making sure that that removal that has been achieved by the project endures, whether it be
Right.
100 years, 1,000 years,
Correct.
however long that might be. So, how does Oscar deal with the permanence obligations, reversal risk, and that longer terms liability? I mean, essentially, whose problem is it if there's a reversal or loss of permanence?
Right. So, I mean, durability is obviously sort of a key element to CDR, right? And how do we handle that from a practical point of view, right? If there is a reversal in 500 years from now, it's going to be difficult to litigate that, right? None of the parties will be around anymore, most likely. So we got to find sort of a practical solution to this. There is there's a durability monitoring period, right, during which the supplier, in conjunction with the verification contractor, sort of making sure that there is no reversal. And then if there is a reversal, what the agreement does, and again, this is because length had so often been come up as an issue in this process. So what we've done here is we've basically referred to the requirements of the standard. We initially had provisions in the agreement regarding reversals and leakages, distinction between avoidable reversals and unavoidable reversals. So, looking at negligence of the supplier, and then have different kinds of remedies for those. So it can become really sort of nitty gritty. What we've done for Oscar now is just to say, let's just refer to the standard that the parties agreed on would apply for this project. And then whatever the standard requires, that should apply. But again, one can look at this also in a more complex way, right? And have a whole sort of triangle of clauses and say, there's an avoidable reversal, unavoidable reversal, within a certain period of time, and then have different kinds of remedies to that. We haven't done that here, so to keep it simple. But from a practical perspective, there's a monitoring period. And if there's any reversal during the monitoring period, then the supplier needs to provide new or additional credits to the buyer to make up for that shortfall.
Yeah, thanks, Peter. I have to say, what I'm enjoying about the nature of your answers is you're giving an indication of ways in which buyers or sellers may end up negotiating the Oscar away from the starting point, but you're also explaining why the starting point was arrived at for a variety of reasons to at least have a starting point for that negotiation between buyer and seller. So thank you for that insight. Pricing and payment mechanics, you talked briefly about prepaying for forwards. if you're entering into a prepaid forward, then you as the buyer might be financing the project without them to need to go to a bank or commodity trading firm or fund or anybody else to get that finance. And you will be concerned that if you're giving this developer cash up front and you're going to get credits in future years, you want to make sure they're using that cash in the way that you understood, and maybe you saw a financial model before you entered into the offtake agreement. So what are the pricing and payment mechanics that perhaps protect the buyer in terms of prepayments, milestones, and so on? Does it envisage that the buyer will just pay up front, or is there a milestone-based mechanic that sees a release over time, or is it completely flexible as to how payments work?
Right. It is. It is flexible. There are sort of different sort of payment mechanisms or different alternatives for payments in the agreement, which the parties can basically choose from, right? So, I mean, the baseline, the starting point would be, as in any offtake, payment upon delivery. There is an option for prepayments. There is, you might even say, maybe I sign an offtake before the project has even become operational, sort of very early stage, right? And you might say, well, I'm going to give you something, I'll pay something upon commencement date of the operations. That could be one milestone, for instance, right? But there can be additional ones. One thing the agreement does not do, it doesn't have conditions precedent, right? Which we also sometimes see. The frontier agreement, for instance, has a number of CPs, which is fine from a buyer's perspective, but it can also be quite onerous on a supplier, right? You basically want them to be operational at a certain point in time. And what kind of milestones there are in between signing and that commencement date aren't maybe really relevant, as long as you get there on time, right? I mean, I've seen contracts where it sometimes says by X date you need to have achieved this, and by date such and such you need to have achieved this kind of milestone. I would say that's not really, maybe that's not really relevant, right? And it is just sort of fine to have, like a quarterly update and saying, hey, by the way, this is what we've achieved in the last 3 months. We're on a good track, or we're not on a good track. We're running into issues. But I would be sort of cautious with milestones, because again, we want suppliers to be able to focus on their project, developing their technology, and get it up and running. But there are sort of different kinds of alternatives. You could either sort of check the box what kind of payment mechanism you would like, or you can just delete the alternatives that aren't relevant. So Oscar provides for different kinds of payment mechanisms.
Thank you. So we're going to move into where do we go from here in a minute. But one last question before we do, which is around bankability. You've touched on bankability, and increasingly important is insurability. So are there comments that you can readily anticipate that bankers or lenders more generally and insurers will insist go into these documents when they're negotiated in anger? Or do you feel that they're 3/4 of the way to where they likely need to be, and you'll leave it to the lenders and insurers to make that last jump?
I mean, from a lender's perspective, I would say the two core elements are payment terms and termination rights. So they want a lender wants to make certain that they get their money back by a certain period of time. So and they need to understand as to when a supplier is being paid. Um, they want to make certain that there aren't any, price adjustment clauses that add a layer of uncertainty as to what the price of the credits are in 2 or 3 years from now. So they want to have sort of, I mean, if the price increases and there's a price adjustment clause to the benefit of the supplier, a lender wouldn't have a problem with that. But there needs to be a floor. And the other aspect is obviously termination rights for the buyer. You don't want a buyer to be able to walk away from a contract too easily. If there's an event of default, if no credits are being delivered, and there's a substantial issue with the project, obviously a buyer needs to have a termination right, and any lender would understand that. But clauses like, we can terminate at any time within the next 2 years upon 3 months' notice, that's not going to fly.
Right.
So there needs to be a balance. It's also interesting in the sense of, I mean, we use the term bankability sort of very widely, but depending on what lender you are talking to, different lenders may have different requirements as to their bankability standards, right? It's not that every bank sort of has the same requirements. Even within the same bank sometimes, depending on who department you're talking to, they may come up with different different ideas, requirements, and conditions. So that's going to be that's really something that will come down to the discussions when a supplier is looking for a loan.
Yeah.
But what I can say is sort of that, at least for Oscar, the feedback that we've gotten is that that is something a bank would work with. This does not mean that they say this is great, no questions asked, right? Obviously not, but it is. But it is something. It could be a good starting point when you talk to a bank.
Yeah. Okay, so we're going to go to Q&A in about 6 minutes' time, Peter. So I'm going to ask you 6 or 7 questions in the next 6 or 7 minutes, and I'm going to give you a maximum of 60 seconds to answer each question. Okay, so quick fire questions,
Right.
and they're all going to focus on where do we go from here, and how do we get adoption, and so on, and how's it going to evolve. So question 1, the Oscar assumes that the governing law is the state of New York. I'm here today in England. I typically advise on English law governed offtake agreements and so on. So where do we go from here in terms of adapting it to UK, Europe, Singapore, state of Ontario, anywhere else that might want to use it?
Right. So there's already an English law firm, Gately Legal, that is working on making this agreement subject to English law. I'm working on one. I basically have it ready for German law, since I'm sort of also advising a lot of German transactions in this space. I think can relatively easy be adopted to other jurisdictions. Obviously, I can't, talk about sort of for every jurisdiction, but it will be required to adopt it to other to the laws of other jurisdictions. English law is a very prominent, governing law in this space, obviously.
Yep.
Continental Europe as well. So this is doable, and we're already working on it.
Perfect. And a question about adoption. What will determine whether this becomes a market standard, and what might the biggest barriers be, and who are the ideal early adopters and fast followers?
Adoption is obviously going to be key for this, right? It may be a nice agreement, but when it dies in the shelves, it doesn't, it doesn't make sense. So adoption is key, and it's being adopted already. It's already being used in the market. For instance, Senken, they're using it for their transactions.
Right.
There are other intermediaries that are looking at it. Abatable, ClientFi. Cure8 is looking into developing an English law agreement based on Oscar. So it is, and there are already transactions today where Oscar is being used, and these are substantial transactions with very well known suppliers. So yeah, but it's going to be key to for people to adopt it and to get involved.
That's some really exciting product market fit straight out the gate. So congratulations. And in terms of future evolution, how might the template evolve, and what might the governance be as both CDR pathways and regulation changes over time?
Right. So what we basically try to do here is sort of holding up the mirror a little bit against to stakeholders in this market, and make them sort of realize of the risks that are involved in this space. Very often they are not, or they have a very naive approach to this. So what we want to do is people look at this. There is a tool on the website of CDR FYI for people to comment on it. And that's what we want to do. We want people to engage with this agreement, share their experiences in using it, so that it can develop over time. We're not gonna what we did not want to do is we didn't want to sort of put it out there and say that's it and leave it alone. We're basically just getting started in putting it out there. And then we want to help people to evolve it over time, to really develop a standard where as many stakeholders as possible have had the opportunity to contribute in developing it.
And then last question is if a supplier or a buyer is going to use Oscar for the first time, to which particular clauses should they be paying close attention?
Obviously, sort of, I would say, as in any purchase agreement, if you buy wholesale apples or pears, pricing, default provisions, remedies. And these are sort of because at the end of the day, a CDR offtake, it's only just a purchase agreement if you look at it in a very simple way, right? And as in any purchase agreement, the seller wants to make sure, when do I get paid? The buyer wants to make sure, when do I get what I paid for? And what happens when I don't get paid or when I don't get delivered? So purchase payment terms, delivery terms, events of default.
Thank you. And just before we jump to Jason and questions from the Q&A, is there a closing message or a closing thought you'd like to leave the audience with?
I mean, it is really, I think the key aspect for us really is we need to get people, we want people to get engaged and involved in this process. Comment on it, criticize it, use it, share your experiences when you use it. We also want other law firms in, and as you said, the jurisdictional aspect. We would like to, for law firms in any jurisdiction, to look at it and make it, workable under their laws and regulations. So the key aspect for us is really we've given it freely to the market. This is a purely pro bono voluntary effort. I mean, you could look at it almost from a very, almost from an ethical perspective. If we want to work on climate change, and we want to solve climate change, we got to collaborate. Mankind needs to collaborate. And if this, this can be a small microcosmos of this, where any stakeholder in the CDR community is invited to contribute and to move this forward. Because if everyone's getting involved, then we will be able to really develop a standard.
Thank you, Peter. So the message is that this publication is the firing of the starting gun, not getting over the finishing line, and that it's a team sport. So let's share experiences as we go along. With that, thank you, Peter, for your insights and so clearly communicating the whys, the hows, the whats, and where do we go from here. I'll hand over to Jason to share some questions from the audience and take it away from here. Thank you, Jason.
Splendid. Thank you, Simon, for doing such a great job of unpacking some of the details with Peter. Also noting, yes, this is a agreement that's publicly available. Also, just to be very clear, does not itself constitute legal advice. So please consult an attorney when after downloading Oscar from the CDR FYI site, which I offered up in the chat. So take a look at that link, which should have all the documents. Including the boilerplate, including the guidebook for you to take a look at. Also, thank you to our audience. Really good questions coming in. Peter, just to pick up on one of your comments toward the end here about pricing, Sherry Segal asked something that got upvoted a couple of times about what mechanisms does the agreement use for lenders to set floor prices or determine the forward price curve that is used, such as MSCI, et cetera?
Right. So there is there is basically no price adjustment mechanism in the agreement, right? So with one, so the floor price would be the price that you define in the agreement, and there is no price adjustment clause in the agreement, with one exception, which is, however, is in square brackets. So, you might want to delete that. There is a price adjustment clause if during the catch-up phase, so a supplier doesn't deliver. And then if there's late delivery, say a year after the sort of intended delivery date, then the buyer may have the option to reduce the price. That is sort of the only clause in there you might want to get rid of when you talk about bankability, because that could make it a bit tricky for a lender.
Okay, thank you. Question also from the financier side, from Rahul Goyla. Does the template allow for the financier to step in and be the beneficiary to the offtake agreement if the offtake pledges collateral? Again, talking about collateralization of credits. That would allow the transfer of rights to the financier in entirety upon enforcement. As harkens back to some buzz I'm hearing recently in the last several months about places like FASB and IASB recognizing credits as assets themselves. So how does Oscar enable the collateralization is what Rahul is asking about.
Right. So the right for a bank sort of to step in is a tool to, and Oscar, so there's a clause that provides for that. It basically enhances the supplier's chances for bankability. In case there are any kind of defaults. This is obviously something you would need to discuss sort of with the bank as to what they would need, in terms of their also financing requirements. So if this situation arises, the supplier probably needs some kind of financing, and you need to have a bank would then probably also ask for collateral on the credits, which gets you to an area of law outside of Oscar, right? So how do you collateralize a carbon credit? And what is a carbon credit actually? And that is a question that is determined sort of from jurisdiction to jurisdiction, right? So a credit under New York law may be the legal nature of a credit under New York law is different than the legal nature of a credit under German law or French law. So collateralization is important. Yes, it's outside the scope of Oscar because it is something you really got to look at to how do I perfect a security interest over this particular asset. And that is something that needs to be determined on a jurisdiction by jurisdiction basis.
Great. Thank you. Complicated answer to a complicated question. So Peter did a great job of explaining. So thank you for that. Saritha Darla is asking about intermediaries, and this got upvoted a couple of times. For intermediaries who are managing portfolios of CDR deals, how could Oscar create consistency across transactions, and curious about planned tools that could integrate with brokerage platforms to automate the matching process?
I think Oscar, so it is being used by intermediaries already, right? And a number of intermediaries are looking at adopting it. It is the starting point was it's basically an agreement directly between a buyer and a supplier. So if you want to use it sort of as a marketplace or as an intermediary, there are a few adjustments that one should make. But I can tell you from experience that that is not an onerous task. This can easily be done, and it is already used in the market. So if you want to use it sort of as a standard template for transactions on an online marketplaces, this is a good starting point if you want to do it. You don't put it up there and sort of use it without adjustments, but it can easily be. I would say it can easily be transferred into something, translated into something that works for this kind of purpose.
Agree. Again, as Simon mentioned, this is the starting gun. This is the beginning point for contracting. Melissa, who is asking she asked a couple times, does the contract embed some kind of risk mitigation for the failure of the buyer to complete transactions? For example, escrow, insurance, or offtake transfer, indicating that it's especially important for intermediaries who are buying and smaller direct buyers.
Right. Not specifically, other than sort of obviously there's sort of breach of contract remedies. So if a buyer didn't purchase, and they're obviously liable plus interest. But other than that, there's sort of no complex mechanism in there with respect to escrow or other arrangements. Again, that's also due to the fact that we wanted to keep it simple. So what the agreement basically says is buyer needs to pay by such and such date. And if it doesn't, then that's a breach of contract.
Okay, great. Question from a couple of different people about different kinds of pathways and adapting it to different kinds of CDR. Alicia Karspek is asking, can we publish variations or riders for specific pathways? And this also harkens to a question earlier. Can this be adapted to non-durable CDR that's maybe less than 100 years in a permanent, thinking about nature-based solutions in that respect?
I love that question, because in this process of developing Oscar, this is only one of the main questions that kept me awake at night. Is sort of how are we building something that can, be adopted as widely as possible, depending on pathways, right? And it is something sort of I'm thinking about to build actually an offtake for different kinds of pathways. What this does now is I think it is a very good baseline. and that can, again, easily be amended for any kind of pathway. It's designed for durable, but you can also, you could use it basically with a few adjustments, keeping in mind also market peculiarities and specificities for certain, for certain kind of pathways. DAC is one particular one, which is sort of very, it's very nascent, and there have been difficulties in sort of issuing and delivering credits. So one might have, one might want to be a bit cautious in terms of the remedies there from a supplier's perspective. But these are all things that can be tweaked if you use this agreement as a starting point. Ideally, at some point, we would have an agreement where we'd say, use this for biochar, use this for DAC, use this for ocean, and with certain footnotes and comments. This is trying sort of to combine everything for now as a starting point.
Great. Last question, real quick. From Christoph, how does this relate to registry requirements? How does this integrate with initiatives like ICVCM and SBTI?
Right. So it is, again, sort of, there is basically only in terms of registry requirements, there's only a reference to whatever the registry is and what kind of registry requirements those are. On the compliance side, SBTI, there isn't, I don't see, well, maybe two aspects. So one of it is it's written as a New York law agreement, right? So it's basically for a US transaction. So, and we're gonna be, we're far away from any kind of compliance requirements, at least on a federal level in the US. And even in Europe, I mean, there's sort of now the certification framework, but I don't see a lot of compliance requirements on the horizon. So if there is sort of a change of law provision in the agreement. So if there are any kind of adjustments required, or if there are any kind of laws, rules, or regulations being adopted that make it impossible to implement that agreement, there's a termination, right? The process would be it's basically a bit of a vague clause in the sense that parties need to get together and negotiate in good faith if legal requirements, compliance requirements, sort of ask for any kind, or make any adjustments to this agreement necessary. So there is that kind of flexibility in a sort of loose wording.
Thanks. And with that, we are at the top of the hour. So I want to thank you, Peter, and thank you, Simon, for conducting such an excellent discussion. And thank you to our audience for, again, such probing, excellent questions. And look forward to seeing you, first of all, tomorrow, same time, at a CDR.FYI and Oscar webinar talking about key terms and really getting to the nitty-gritty of the details of the contract itself and its clauses. So this can be at the same time, 24 hours from today. And once again, this webinar will be recorded. Is being recorded, as will tomorrow's webinar. So it should be available later on. What I would like you all to do, though, is just join me in a round of applause for the speakers, and look forward to hearing your comments about Oscar as it gets used. This is going to make the agreement as effective and impactful as it can be in the industry today. The more feedback we hear from you, the better off the document's going to be, the better off the transaction is going to be, and the healthier the function of removing excess CO2 from the atmosphere is going to work in the future. So once again, thank you, and we look forward to hearing your use cases and feedback about the Oscar contract and guidebook. Thanks, and we look forward to seeing you soon.
Thank you.
Thank
Thanks,
you.
Jason. Thank you, Simon.
Thanks to you both.
Cheers, all.